Good afternoon. This session is about CDD and record keeping and other statutory AML/CTF requirements. First of all, when TCSP licensees carry out a transaction concerning a trust or company service for a client by way of business, they are required to carry out CDD measures under the AMNO. Section 3 of Schedule 2 of the AMNO sets out when TCSP licensees should carry out CDD measures. Please note in particular that licensees should carry out CDD before establishing a business relationship with the customer. So it is before but not after. For example, they act as a company's secretary for a new customer. The CDD measures under Section 2 of Schedule 2 are set out in this slide. As we have gone through these in our AML seminars in the previous years, this year we will focus on the requirements which may be overlooked, and we will demonstrate them with case examples in order to highlight the common problems. For the CDD measures, there are some common deficiencies. First, for example, certain documents set out in the appendices of the AML guideline have not been obtained for verification of customers and their beneficial owners. So you should check whether the information and documents required in the applicable appendix of the guideline have been obtained. Let me give you a case example to illustrate the application of the appendix of the AML guideline. Here is a common example of a transaction carrying out by our TCSP licensees when it, by way of business, provides the service of acting as a secretary of a company, say Company X, which is a new customer. The licensee is required to carry out CDD on Company X before establishing the business relationship. In this case, as the Company X is a corporation, then the licensee should identify and verify the corporation. Simply obtaining the HKID card copy of the director of Company X is not sufficient. The licensee should obtain information and documents in accordance with Appendix B of the AML guideline, which is applicable when the customer is a corporation, such as obtaining a copy of the certificate of incorporation, a copy of the business registration certificate, articles of association, details of the ownership and control structure of the company, for example, an ownership chart, and a list showing all directors of the corporation. If simplified CDD under Section 4 of Schedule 2 to the AMNO does not apply, the licensee should identify the beneficial owner of Company X and take reasonable measures to verify the beneficial owner's identity. As the beneficial owner is an individual, the licensee should collect the information and documents set out in Appendix A of the AML guideline, such as obtaining a copy of the Hong Kong identity card of the beneficial owner. Another common deficiency concerns the situation where there is a person purporting to act on behalf of the customer. That person's identity has to be identified and verified as well. Licensees should obtain written authority, including board resolution or similar written authority in case the customers are corporations, to verify that the individual purporting to represent the customer is authorized to do so. Another area to note is in relation to CDD conducted by the licensee's intermediary under Section 18 of Schedule 2 to the AMNO. Subject to the requirements set out in Section 18 of Schedule 2, a TCSP licensee may carry out any CDD measures required under the MNO by means of an intermediary if the intermediary consents in writing to be the licensee's intermediary. Please be aware that, in other words, there must be a written consent. This is definitely necessary and important. And the licensee has to be satisfied that the intermediary will, on request, provide a copy of any document or record of any data or information obtained by the intermediary in the course of carrying out the CDD measures without delay. However, we have to bear in mind that, in any case, the ultimate responsibility for ensuring that CDD requirements are met remains with the licensee. Also, it is very important that intermediaries carrying out customer due diligence measures under Section 18 of Schedule 2 to the MNO must be a specified intermediary under Section 18, subsection 3 of Schedule 2 to the MNO. The intermediary should be subject to CDD and record-keeping requirements in line with the MNO and be regulated, supervised, or monitored. It is not the case that any unregulated entity can do so. Let's see the slide here. TCSP licensees may carry out any CDD measures by means of a FI, a financial institution that is an authorized institution, a licensed corporation, an authorized insurer, a licensed individual insurance agent, licensed insurance agency, or licensed insurance broker company. And TCSP licensee may also carry out any CDD measures by means of an accounting professional, an estate agent, a legal professional, and a TCSP licensee if they are able to satisfy the licensee that they have adequate procedures in place to prevent money laundering and terrorist financing. Licensees may also carry out CDD measures by means of an intermediary in an equivalent jurisdictions if the following can be satisfied. As for the definition of equivalent jurisdiction, it means a jurisdiction that is a member of the FATF other than Hong Kong, or a jurisdiction that imposes requirements similar to those imposed under Schedule 2 to the MNO. So licensees may carry out CDD by means of an intermediary in an equivalent jurisdiction where the intermediary is, for example, a lawyer, a notary public, an auditor, a professional accountant, a TCSP, or tax advisor practicing in the jurisdiction, or a person who carry out in the jurisdiction a business similar to that carried on by an estate agent or by an intermediary financial institution, which I have just mentioned in the previous slide. Provided that the intermediary is required under the law of that jurisdiction to be registered or licensed, or is regulated under the law of that jurisdiction. And also, the intermediary has to have measures in place to ensure compliance with similar CDD and record-keeping requirements as those imposed under Schedule 2 to the MNO. And the intermediary has to be supervised for compliance with those requirements by an authority in that jurisdiction that performs functions similar to those of any of the relevant authorities or the regulatory bodies. Please also read paragraphs 5.46 to 5.54 and the relevant task boxes in our AML guideline. This slide sets out the situations when the licensee is required to carry out CDD measures for pre-existing customer. That is, those with whom the business relationship with the licensee was established before the 1st of March 2018. For example, where a transaction which is unusual or suspicious, and when the licensee suspects that the customer is involved in money laundering or terrorist financing. And in all cases, whether your customer is a new customer or a pre-existing customer, TCSP licensees also need to continue to monitor the business relationship with the customer, including by reviewing from time to time documents, data, and information relating to the customer to ensure that they are up to date and relevant. Licensees should undertake periodic reviews of existing records of customers and conduct review under circumstances of certain triggering events. For example, when there is a material change occurs in the way the customer is operated. In certain higher risk situations, licensees are required to take additional measures as EDD, enhanced customer due diligence, in addition to the CDD requirements. High-risk situations for which EDD apply include situations where the customer is not physically present for identification purposes. Second, where the customer or the beneficial owner of the customer is a politically exposed person. And in any situations specified by the Registrar of Companies in a notice given to TCSP licensees, and in any situation that by its nature may present a high risk of money laundering or terrorist financing. For instance, where the customer is from a jurisdiction that does not adopt or insufficiently adopts the FATF recommendations. Non-face-to-face situation and PEPs are important areas which licensees must pay more attention. In particular, if a customer has not been physically present for identification purposes, EDD measures must be carried out, such as further verifying the customer's identity on the basis of documents, data, or information, such as further verifying the customer's identity on the basis of documents, data, or information not previously used for the purpose of verification of the customer's identities. Please look at Sections 9, 10, and 15 of Schedule 2 to the AMNO and Chapter 5 of our AML guideline for the EDD measures to be taken. Another area under Schedule 2 is the record-keeping requirement. The key requirements for the records of transactions and customers to be kept and the duration of keeping such records are set out in this slide. And I think you should be familiar with them by now. As we have received questions asking whether licensees are still required to keep records after resignation from the position of company secretary of a customer. So I would like to remind licensees that even the licensee resigned from acting as a company secretary for a customer, the licensee should still keep records of that customer for 5 years from the date of its resignation. As mentioned last year, I would like to remind you again of the general requirements under the AMNO on establishing effective procedures for conducting CDD and EDD, as well as to mitigate money laundering and terrorist financing risk. Apart from the requirements under Schedule 2 to the MNO, which I have just talked about, our AML guideline also highlights some other AML CTF statutory requirements. In relation to financial sanction, making available or dealing with economic assets belonging to individuals or entities designated by the UN Security Council is prohibited by the relevant regulations under the United Nations Sanction Ordinance. As for terrorist financing, TF, the United Nations Anti-Terrorism Measures Ordinance criminalizes the provision or collection of property and making any property or financial or related services available to terrorists or terrorist associates. So please be reminded not to establish business relationship or conduct transactions with any individuals or entity subject to financial sanctions, or any terrorist or terrorist associate. Please refer to Chapter 8 of our AML guideline for more information. As deficiencies in this area are common, we would like to remind licensees again to pay close attention to the latest list of individuals and entities designated. Licensees should ensure that they have an appropriate system to conduct name checks against the updated list and conduct ongoing screening of its complete customer base. The most up-to-date list of sanctioned persons and entities are available at the website of the company's registries, trust and company service providers licensing regime, as well as the website of the Commerce and Economic Development Bureau. For PF, that is, financing of proliferation of weapons of mass destruction, the relevant legislation and regulations are set out in this slide, and please note that it is an offense under Section 4 of the Weapons of Mass Destruction Control of Provision of Services Ordinance to provide any service to another person where he believes or suspects on reasonable grounds that those services may be connected to PF, including, for example, the lending of money or other provision of financial assistance. In the following section, Mr. Tan of the Commerce and Economic Development Bureau will give a presentation on risk assessment and mitigation in relation to PF as well. As for reporting suspicious transactions, the relevant legislations are set out in this slide. And Ms. Sham will give a presentation on the methods of money laundering and terrorist financing and suspicious transaction reporting later this afternoon. Last but not least, here is a case study showing the non-compliances of a licensee. The licensee failed to conduct CDD in accordance with Schedule 2 and the appendix of the AML guideline, which I have talked about earlier. Also, the licensee failed to produce an AML CTF policy statement for our inspection. In this case, licensee just simply showed our inspection officers a copy of the AML guideline published by this registry or other regulatory bodies. But this is not acceptable. Our AML guideline requires licensees to assess the money laundering and terrorist financing risks of their own businesses, also develop and implement policies, procedures, and controls, and establish and implement AML CTF systems, taking into account factors such as the services offered and the types of the customers. If policy statement is not prepared for the licensee may also contravene the license condition, which requires that the licensee shall put in place adequate and proper AML CTF procedures, policies, and controls, as evidenced by policy statement or other written documents. Another deficiency is the failure to conduct a risk assessment to identify, assess, and take effective action to mitigate the money laundering and terrorist financing risks as required in Chapter 4 of our AML guideline. Also, there is deficiency in customer screening against list of terrorist and sanctioned destinations, which are common. The licensee here, in this case, said it did conduct screening against the name of the customer, but there is no evidence showing that it did. So please make sure that the screening and any results should be documented or recorded electronically. Simply just printing out the list of sanctioned destinations from our website or the CEDB's website is not sufficient. The licensee should actually keep record of the screening. For example, keep record of the name of the persons or entity screened, the date of screening, and the result of the screening. Another non-compliance is in relation to the requirements of politically exposed person, PEP, under the two sessions, the two requirements in Schedule 2 to the AMNO. First, a licensee must establish and maintain effective procedures for determining whether a customer or a beneficial owner of a customer is a PEP. For example, by making reference to publicly available information and or screening against commercially available databases. And when licensees know that a customer or its beneficial owner is a PEP, they should, before establishing a business relationship or continuing an existing business relationship where the customer or the beneficial owner of the customer is subsequently found to be a PEP, the licensee have to carry out enhanced customer due diligence measures under Section 10 of Schedule 2 to the AMNO. If, for example, the licensee contravenes a requirement set out in Schedule 2 or a condition of the license, the registrar of companies may consider the circumstances and take disciplinary actions. For example, public reprimands, imposing pecuniary penalties, and or remedial orders. This is the end of my presentation. Thank you.